So, good morning, everyone. Thank you for joining our webinar. We have attendees this morning from Latvia, Estonia, and Finland. That is absolutely great. This webinar is a part of our LEF Network Azerbaijan project, and if it's okay, I will shortly tell you a bit about what we are doing. So my name is Mikko Lehtonen and I come from Satakunta University of Applied Sciences, SAMK. At the moment from very chilling Finland, it's minus 12 degrees or something like that here in Satakunta. And together with my colleagues in this project, we help companies from Latvia, Estonia, and Finland to establish and do business with Azerbaijan. In the project, we have made already 4 trade missions to Baku, Azerbaijan, with over 40 different companies, and we have 1 year left in this project, and we are doing two trade missions this year to Azerbaijan, and the next one is already early March. I think some of you are joining us, and some of you have been formerly at our trade missions. One important part of the project is also incoming trade missions from Azerbaijan to our regions. We bring interested companies from Azerbaijan to get to know our countries, to get to know our culture, and of course meet our companies here. And 2 these kind of incoming trade missions are being held this year. And the next one is scheduled to 7th till 12th of April this year, and the delegation from Baku will get to know Pori, Satakunta, and Tallinn, Estonia, and Riga, Latvia. They will meet our companies and get to know our countries this way. And also we have other aspects in the project, like these educational webinars you are now attending. We also, for example, do market research. If you are interested, thinking about doing business in Azerbaijan, we can do some market research for you. So please be in contact if you're at any level interested in this. What else? Here, our partners in this project are, our lead partner is Latvian Chamber of Commerce, and from Estonia, our partner is Estonian Chamber of Commerce, and we have done great cooperation many years with our great partners, and hope that our cooperation will continue in the future. So that's enough of my topics. We have an important webinar topic, enforcement risks, coming up. We have the best expert in Finland, legal advisor Petri Kekki from EastCham, Finland, telling us topics about this. And at the end of the webinar, you have a chance to give questions. You can put them in the chat or present them vocally at the end of the webinar. So, please, Petri, the floor is yours.
Thank you. Good morning, everybody, on my behalf also. As you heard, I'm a legal business advisor, Petri Kekki, and I work in the EastCham, Finland. My main task is give the support and advice to the Finnish export companies targeting to the Central Asia, Caucasus, and Ukraine. Ukraine is at the moment, of course, more or less in the launching pad because of the full-scale war that Russia started against Ukraine. But I give also also basic legal advice, information about the legislation and that kind of things. The main purpose of this training session today is to provide you a comprehensive picture and overall framework of sanction compliance. The goal is that you learn to understand what this know your customer compliance process means in general, and what factors influence its implementation, and of course some information of the novelties of this new sanction regulations concerning today's topics. So the content of the presentation is following that. First, the seller's responsibilities in sanction compliance and seller's obligations in the sanction environment. That is, what actions can be expected from the seller in practice. And know your customer sanction compliance process for sanction regulations. And this is this content of this know your customer process is divided in this presentation in separate sections, meaning that first we have a look about if the product or service is subject to sanctions, when this happens, and is the trading partner itself on a sanction lists, and planned sanctions and sanction circumvention when this sanction evasion comes in the picture. And related to this is the identification of the end user, what questions we have in those cases, what must have been taken under consideration, and of course then updating contract clauses. What can be taken under consideration, shall we say, contractually? What possibilities we have there? And then last but not least, the organization internal processes, meaning filing documentation of the know your customer process in writing. What must be taken under consideration and how to complete that process, what is important, how the process will go, and what is important. And some words about what new elements did the latest sanction packages bring to this overall framework, and of course last a short summary of all the information you received today. The seller's responsibility for compliance with sanctions. We must keep in mind that sanctions are directly binding legal provisions for companies. They are in effect and in force like a law, as a law. And that means that sanctions impose obligations on companies and individuals also in the same way as regulations concerning, for example, data protection and shall we say anti-money laundering, and of course any other issues in the Finnish society. In Finland especially, a violation of sanction is considered a criminal offence. It's a part of our criminal system as any other criminal legislation. And the penalty scale is from minor to severe forms, and the potential penalties include fines or imprisonment, meaning the scale is for 4 months to 4 years, And there's also the possibility to corporate fines, and the scale is there from 850 to 850,000 euros. So those corporate fines can be extremely high in some cases and must be taken very seriously. The main thing that must always keep in mind that the act requires intent, meaning that you have intentional work in order to be punished in a criminal offense way, and in meaning that to avoid liability, all these business activities related to the matter must be conducted in a good faith, bona fide, meaning that the person must basically understand that the act is against the sanction regulations. If you act in a good faith, bona fide, you usually don't get punished according to these criminal provisions. But of course, the court will consider the situation in a case by case. So it's impossible to say beforehand what's the result would be if we go to the court. And we must always keep in mind that the seller is obligated to take initiative and actively participate in carrying out this know your customer processes. There are some guidelines that how this authorities emphasize the company's obligation to investigate the situation independently. The guidelines says that ultimately the legality of export remains the responsibility of the exporter. They use the expressions that the company should investigate, the company should ensure. So the starting point is that the company itself is responsible to complete these activities and to make sure that all the important aspects has been taken under consideration. This is important to know. And of course, therefore, the company must be proactive and active in investigation in the sanction situation and, what is important, documenting it. We will come later back to this documentation process and things that must be taken care of. Filing the information. And to avoid the intent required for criminal liability, as I already mentioned, those actions you take must align with those of a reasonable, prudent person, as they say. And so that means that the actions should always be conducted in good faith, bona fide. Meaning that you really have tried to, in a good faith, try to figure out what is it's all about and what questions are important related to this case, and you try to collect all the information important in relation to the sanctions. And then finally you have documented it properly. This practically involves a certain duty of care, as I already mentioned, which is adjusted according to the company's resources and ability to investigate the sanction situation. Meaning, for example, this possible circumvention of sanctions and delivery, distribution chains, etc. But to be honest, in practice, in real life, identifying this actual owner is difficult. It's only maybe difficult. It is difficult, or in some cases, it can be even impossible with the normal resources. But as I mentioned, some kind of proportionality is always in picture in these cases, meaning that this will evaluate the situation will be evaluated in the basis of proportionality, meaning that, shall we say, one-man band, that a smaller company has different requirements than, shall we say, some kind of company that operates worldwide and have huge resources compared to this smaller, medium-sized companies. So we must always take under consideration the resources the company have. And as mentioned, when you investigate the work properly and properly documentate, it can help minimize potential criminal liability. You have then the ability to demonstrate the existence of an appropriate compliance process, this know your customer process, and you can show that with the documentation you can show that you have followed your process you have already imposed in advance. That is critical if there will be some kind of inquiries after this process. What does this know your customer process means? What this compliance, sanction compliance is all about? Shortly, we can say that this all the processes that help company follow the law, and sanction compliance process refers to the pre-planned for the first and necessary procedures through which the company ensures, based on an objective assessment, that the planned transaction is entirely free of sanctions. So it must be pre-planned, that is important, and include necessary procedures that company can ensure that the business transactions you are planning is so-called sanction-free. And this process involves many areas, all of which must pass the compliance check before the business transactions can be executed. And we talk about sanction screening when talk about these checking all these areas which this compliance process include. And any potential sanction listing of the business partner must be identified. And this includes also the partner's ownership structure and actual decision makers, possible beneficiaries, meaning potential ultimate controllers. And after that, this process must then determine whether the product or service itself is subject to sanctions. And then observing the indicators of indirect circumvention of sanctions is very important. And identifying the possible end users is important, especially when we have, for example, some kind of supply chain or distribution channels, which companies quite often have. In that case, the checking out the end user is important. And of course, then incorporating sanction consideration in the contracts, drafting suitable clauses in the contracts is important. And then, of course, as I already mentioned many times, the proper documentation of this process and its outcome is very essential. And sanction report related to the self-trading partner. We must keep in mind that the definition of these resources is very broad. So almost anything that has financial value can be the target of the sanctions. And no benefits of financial value may be made available to a sanctioned person. Even cash and all other benefits of financial value. So this is very broad definition. And of course the risk always increases if there is a Russian person or Russian company involved in for example, in the supply chains or distribution arrangements. And in addition to the sanction situation, it is very necessary to determine its ownership and effective control and decision-making status, meaning that membership of the company's board of directors, chairmanship of the board, and other opportunities to guide the company trading partners' decision-making. And there are software tools that can facilitate the implementation of the compliance process. Our chamber, for example, has a Dow Jones application, which with the help of that application, we get to get information of the membership of the company's board of director and different ownership structures of the company. And then that helps a lot finding out the trading partners' sanction situation. And then sanction compliance related to the ownership. The EU guidelines, best practices for the application of EU sanctions give some information about that. For the first, the ownership of more than 50% of an entity is a criterion that must be taken into account when assessing when a legal person or entity is owned by another person or entity. And if this criterion is met, the legal person or entity is considered to be owned by another person or entity. One example of this was a couple of years ago. This Oleg Deripaska's company Rusalium, in which this oligarch Deripaska owned over 50%, and suddenly everybody noticed that it's not possible for the US to make deals with this aluminium company because Deripaska has this share over 50%, and after Deripaska decreased his share under the 50%, it was again possibility to make deals with him. This was one example that how this affect to the situation. And as I mentioned, sanction search engines usually provide information of the owners and ownership. And also, at least some time ago, it was possible to get information about the ownership of Russian limited liability companies from the Russian trade register. I don't know if this still works. Some time ago, it was possible to access there, but of course, taking under consideration the situation today, the situation may change quite rapidly. And what is important also that it's very important to exchange information on your own initiative with a potential trading partner. So have a face-to-face negotiation if possible, or Teams meeting, etc., and get straight information from your partner, and on the basis of this negotiation make a short memo of the results of this negotiation. This is natural part of the know your customer compliance process. And what does control mean in terms of sanctions and in implementation of this know your customer process? The best practices guidelines provide examples of other types of effective control in the contrary. Usually they are such as appoint or dismiss persons, key persons, have voting rights, or contractual arrangements, control of the assets of the company. So rights of powers to appoint or dismiss a majority of the members, and the ability to exercise these measures by exercising its voting rights alone. Pursuant to an agreement with the company's other shareholders, have rights to determine a majority of the shareholders' votes in the company. This means usually the shareholders' agreement, but unfortunately those shareholders' agreements are according to the business practices of the companies. They are concealed documents, so usually it's not possible to get access to those documents. The other story is, of course, the company charter, which you can find from the trade register, and from the company charter it is possible to get information in some cases. It is mentioned here that the right to exercise dominant influence in the company's pursuant to an agreement of the Articles of Association, if this is possible under the law. In some cases, there will be difficulties to exercise this dominant influence because there are some provisions concerning the minority of the shareholders, and some redemption questions may get into the picture, but I think that we won't get that any deeper of this question. And of course, then right to exercise all these rights via some kind of shell company frontman, meaning that you try to evade those provisions by using a shell company or frontman, and try to hide the actual person who is exercising those powers in real world. And if any of these criteria are met, the practice is that the company is considered to be under the control of another party, and that must be taken under consideration when checking the situation with the sanctions related to this company, which is your potential business partner. And then sanction compliance process for the products or service. A key part of the content of this compliance activities are, of course, export and import bans and sanction lists for individuals and entities, for for example, for persons and companies usually. And the situation in practice is that the sanction regulation with its attachments must be adopted. So usually the situation is that those regulations, in the end of those regulations, are the lists of the products or persons which are under sanctions. And unfortunately, in some cases, it is necessary to even perform a manual review, and then usually you should contact your company's product portfolio expert, a person who is expert with, especially with those items which are target of the sanctions, and then you have to perform manual review. You check manually those attachments and check if your product is listed in the attachment. There are some for example, the custom Finnish database is a good help in mapping these relevant sanction regulations. I have a link there. You can check it yourself and familiarize with the system. But the starting point is that export, for example, to Central Asian countries are not subject to sanctions. So the main rule is that the trade is free. Unfortunately, the situation has changed so these days that seems that the main rule is that the sanctions are the main rule, that there is no free trade anymore, that the ban is the main rule and free trade is exceptions, but in principle it's so that the sanctions are always the exception. But what makes the situation problematic in, for example, especially concerning the Central Asian countries or China, of course, is the circumvention of sanctions through these countries. That is that the exports of products subject to sanctions to Russia, even indirectly, it is prohibited. It is therefore not enough for a Finnish company to state that our customer is not in Russia. But the company should also know what kind of customer it is cooperating with. It must know the customer's distribution channels and its own customer network and its decision-making systems, procedure, and the key persons, decision-making key persons, etc. So it has quite broad it has to be a very broad way to find out what kind of systems and decision-making bodies this your potential business partner has. Then detection of indicators related to indirect sanction circumvention. What is appropriate sanction compliance and evasion warning signs? Sanction guidance give us a little hint of appropriate sanction compliance. It is a reasonable and case-by-case risk-based approach, taking into account all relevant circumstances to ensure that the entity subject to sanctions does not use or otherwise benefit from funds or economic resources. And there is also the Ministry of Foreign Affairs guidance concerning this. There are some typical warning signs, warning situations, so-called red flag situations that a responsible actor should recognize because they aim to promote sanction evasion. That is in practice, the meaning is to disguise the involvement of persons subject to sanctions or other parties in the trade, and by concealing this end user, and they cover operations. Those red flag situations are, for example, as follows. The quite normal is the use of shell companies or other similar instruments to disguise ownership, source of funding, or countries, actors involved in a cover operation, by presenting the shell companies as end users, when the actual end user is completely different entity. We use a frontman by presenting the shell companies as end users, and the actual end user, which is behind the frontman, is a completely different entity. It is the actual end user, not the frontman. And then there is this customer's unwillingness to provide information on the end use of the product and or provide an end user certificate. If customer is unwillingness to give an end user certificate, I would say that it's a sign to withdraw from the transaction completely. I would say that is so unusual behavior, shall we say, in business practices, that in those cases it's better to withdraw as possible from the transactions completely. And unnecessary splitting deliveries of products under the sales contract into multiple shipment without a clear justification, it's of course suspicious. And those situations also when the customer is an industry that is incompatible with the ordered products. For example, if mining company wants to have components which are not in any way compatible with the mining industry or mining business, in that case, it's of course should raise some questions that what is this all about, and further inquiries must be taken place in that case. And of course, if the customer is not familiar with the product features and shows no interest in them, that is of course suspicious also. Usually your business partner is familiar with the product it wants to have, knows the basic features, and is interested of the product itself. And paying clear overprices is not normal. And urgency without a rational justification. We know that in business world there is always a certain time pressure available all the time, but this without any rational reason, urgency is not normal. And of course, cash is not used anymore in the normal business practices. That is suspicious, of course. And those remove or change markings or other information on products or related documents is not normal. Of course, if there is some defects of the marking, etc., then it's understandable that some changes have to be made. But in other cases, it's not normal situation. And usually the delivery includes installation, training, or of course, quite often the maintenance of the product. These are the usual part of the delivery. And if customer refuses of those completely, it is of course very, very, very unusual. And then further investigation and discussions are of course needed. And then all the last minute changes to delivery instructions that conflict with the customer's previous delivery history or other business practices you have with this customer maybe before. And personal email addresses are not normal in the company practices. And if those corporate transactions are especially complex, international companies that use residential addresses or addresses that are common to several closely owned companies. For example, if there are hundreds of addresses in the same building, that can be, of course, not only unusual but suspicious also. Using different pseudonyms to conceal the true identity or intermediaries and end user. And especially if the business units, customers' business units don't have a credible physical presence, meaning normal office with normal office facilities and necessary staff which is needed to run that kind of business activities your business partner is dealing with, that is of course suspicious. And this routing, which have of course discussed a lot of in publicity in the newspapers, that routing of the goods through, for example, from the Central Asian countries, Turkey or China also we must keep in mind. And those countries can use as a transshipment points for those procurements to be directed further to Russia or Belarus, and maybe to the sanctioned persons there. Or the export to Russia can be completely prohibited itself. Identifying the end user, which is of course very essential thing of the know your customer procedure. You have to always ensure the end user of the product if it is reasonable possible, with this exception, meaning that you are using the means that reasonable prudent person in good faith has possibility to use. So there is always at hand that proportionality. So you don't have to do miracles or magic things. You use all the possibilities and information and tools you have at hand, which can be expected, for example, from the small or medium-sized company. That is important. And in business practice, this means negotiating with the buyer to clarify matters and obtaining an end user certificate in a written or in an electronic form. And a written commitment is required regarding the use and final location of the item of trade, and also an assurance that the item of trade will not be sold or delivered to Russia or Belarus or any other party subject to sanctions. And contractual clause is often drafted to the delivery contract. And according to that clause, usually they say that the customer is contractually committed to not transfer to the content of the delivery directly or indirectly. So meaning in the help of sanction evasion to countries subject to sanctions or to entities meaning companies usually, or individuals subject to these sanctions. And the customers is also committed in the sales contract or, for example, in the service contract. But in this case, it is said as in sales contract to act in full accordance with the obligations of the end user certificate attached to the contract, meaning that the end user certificate normally shall be attached to the main contract and it will be an essential part of the contract. It is part of the contract and will be applied as a part of the contractual situation. And some words about the sanction compliance documentations. And the main rule is always that the investigation work you have completed should always be documented in writing, so that if necessary, it is possible to justify to the authorities what the decisions made are based on and why they have been considered justified in relation to your own company's risk profile. So it's important, especially important, to file this information for the purpose of the inquiries of the authorities, because it's possible that they get interested, and in that case you have ready-to-use package to deliver to the authorities. Everything has been taken under consideration beforehand. So in that case, your own activity and your reasonable good faith in clarifying the nature of this business practice, business relationship in case can be objectively justified afterwards. And written evidence in that case is obtained of acting in reasonable good faith like an average diligent person. You can show all this from the documentations to the authorities that all these requirements have been completed accordingly. And all this comes down even to the internet searches. It can be that detailed. For example, internet searches and the information obtained from them should also be documented. And this comes down to the time, for example, the scope and matters raised, the party contacted, that is the questions raised and the answers to them, and if any follow-up actions. You must also file the actions which you have been taking based on this information you have received from the different sources. And of course, you document any other possible information and the time and those methods of obtaining it. That is the seller's exchange of information directly with the buyer. For example, the face-to-face negotiations, or if you have team negotiations, or exchange of email, etc. One option is that you have in your Know Your Customer compliance procedure basic information questionnaire already drafted, which can be used. It's always at hand available and can be used in this situation. And of course, the starting situation must be recorded. That is what has been checked and how, and what the final result of the check has been. If you complete all this and file the information accordingly, you have completed quite successful sanction compliance, Know Your Customer requirements. And especially the investigation must pay attention, and again according to your resources, to indirect transfers, meaning those attempts to evade evade the sanctions. That is kind of many kind of various front organization arrangements, frontman arrangements. So that is the situation where the object of the transaction is intended to be transferred through an intermediary to a listed entity, sanctioned entity, for use of utilization. And as I already mentioned, the company practical sanction compliance is ready in a compact form in a memo, and it's ready to be submitted to the authorities. It's ready to use package if there are any inquiries regarding these issues at hand. So it's really important that you beforehand think about these things and you make this procedure ready to use when these sanction situations appear. Usually when they appear, it is more or less too late to start then thinking about the different aspects. All must be thought beforehand. Then I took one case which will give you a figure of the potential sanction evasion attempt, at least. Recently, an organization called the Kazakh Emirates United Contract Commission, KEUCC, has been very active in the business of Finnish companies. That was happened some time ago. And according to the Austrian Chamber of Commerce, this organization acts as a state actor and procurement organization. Although, according to the Austrian Chamber of Commerce, there are no such state procurement organization in Central Asia, and this organization is apparently not an actual state organization. And those homepage of this Austrian Chamber of Commerce includes further information about this situation. And it said that all of the above organizations claim to be part of the state administration. Such procurement organizations do not exist in Central Asia. And this organization approaches companies with the proper request of tender. So meaning that in principle the documentation they are presenting seems to be okay. And the documentation stating that there is a demand for certain product manufactured by a Finnish company and that they therefore request a brochure, for example, for the first and product catalog and some price information. And according to his announcement, this organization board is cooperating with the authorities of the United Arab Emirates, and according to the information, so that the payment and the shipment delivery of goods run smoothly. This was the information received from one customer email. This was their explanation why they have this cooperation with this United Arab Emirates. And in addition to this information, this organization does not provide any actual valid legal basis for why they and UAE has been included in this activity. And furthermore, this organization website lacks the mandatory information regarding the organization identification number according to the Kazakh law. And the website does not show this organization's legal identification number. And especially this is suspicious because this must always be used to identity a legal entity. And there also seems to be some obscurity in the spelling of this organization's personal information. The names consist of incorrect combination of the names of government officials. The website also contains many publicly available images of the Kazakh state administration, but without a solid relationship to KEUC's activities. So those images are publicly available, but they have not solid connection, reasonable connection to the organization's own activities. And based on all this, we must keep in mind the fact is that there are shell companies in Central Asia with professionally made, seemingly credible websites and furthermore qualified language-savvy people to answer inquiries. But however, the background parties and ultimate beneficiaries of these actors may be found in the end in Russia. That is unfortunately the outcome of this situation. This is one example of the potential sanction evasion attempt. And then contract clauses related to sanction. There are, of course, also some, but unfortunately limited possibilities to manage sanction risk contractually. But it always, of course, worth trying to manage sanction risk also in the contracts. You better try to ensure that the contractual actions can be refused and the contract terminated if possible, if sanctions require it. But you must take today into consideration also the position of Russian legislation on Western sanctions. Russia has imposed several anti-sanctions provisions, which of course hamper these possibilities to use relatively effectively those contract clauses related to the Western sanctions. And for example, there are difficulties to directly invoke force majeure situation because Russia's attitude is a problem. Russia don't accept all the questions related to the sanction as a force majeure situation. And in trade agreements, there often contains a condition according to which both parties to the agreement must comply with the sanctions. And in practice, it's of course also good to agree as concretely as possible on what procedure is always prohibited, regardless of the substantive legislation applicable to the agreement. That is, for example, forwarding products delivered from Finland to problematic end use in Russia in terms of sanctions, and forwarding products to end users subject to sanctions. That should be, those activities should be prohibited. And then, if possible, we may include some damage clauses which may ensure the compensation from breach of contract in some cases. And extreme attention should be paid to dispute resolution clauses in contracts. That means those arbitration clauses, which usually the international trade contracts include. And that means that you may agree that in which procedure the dispute will be handled, in which country, and according to which country's law, and in which language. And naturally, the aim is to attempt to get the handling out of Russia's legal influence in all cases. For example, try to get to the Central Europe or to the Stockholm Arbitration Institute, etc. There are many possibilities. with the dispute resolution clause in contracts is the attempt to transfer this legal proceedings arbitration outside of Russia and to apply the law of a third country. For example, try to get to the maybe Sweden is difficult these days because Sweden is also a member of the NATO, but for example, to some other country and using, for example, the English law is quite usual possibility in the international contracts. But in any case, try to get it out from Russia, this handling of the case. That is important. Well, now then, what new features do the latest sanction packages contain to prevent sanction evasion? There are now possibilities to sanction list entities that circumvent sanctions and assist in circumvention in any way. The sanctions will expand normally export and import bans and transit bans through Russia, as well as individual sanction lists. This is the usual case always when we get the new sanction package, that they will expand those export and import bans, and an individual sanction list will be added also. Now we have also so-called anti-circumvention tool, which is a ban on deliveries to third countries whose legislation allows for continued circumvention of sanctions, meaning that countries which give possibilities to the third countries that give possibilities to the companies to evade the sanctions on basis of their own legislations, for example, which are negligent or don't mind about that kind of activities. And new grounds for adding to the sanction list include efforts to facilitate the circumvention of sanctions and significant violation of sanction compliance, meaning those third countries and their companies there, which facilitate the circumvention of sanction and significantly violate the sanction compliance. And this new mechanism will be introduced to list companies operating in third countries that participate in the circumvention of sanctions. And this mechanism includes a list of products subject to the export ban and list of entities to which the product in question may not be exported. And the granting of export or exemption permits will be prohibited completely to the entities operating in third countries that have participated in the circumventions of sanctions or assisted in the circumvention. And this is, of course, an expansion of the listing criteria for the circumvention of the sanctions. And it is possible in the future that entities that promote the violation of the prohibition of the circumvention of sanctions contained in Council decision and regulation on that otherwise systematically act contrary to the purposes of the sanctions may be subject to personal sanctions themselves. That is also possible at the moment and in the future. And there are further tightening of transit ban, and the list of goods subject to sanctions transported via Russia to third countries is being expanded to prevent circumvention of sanctions. Reporting obligations on payment transactions for Russia-owned companies operating in the EU has been also expanded. And non-Russian clause has been also added to the toolback. That is, in future, exporters of certain products must include in their trade agreements an obligation for the buyer to prevent the products from ending up as a re-export to Russia or for other use via Russia. And these products include, among others, products and technology used in the aviation and space industries, aviation fuels, firearms and supplies, and a wide range of electronics such as microprocessors and radio navigation and radio remote control devices. And these extensions are being added to the list of sanctions or individuals and entities, as well as some addition to the export ban list, including transformers, inductors and capacitors for drones. And especially the responsibility of EU companies to prevent the circumvention of sanctions is highlighted in the 14th sanction package. And that means that the companies must ensure that the sanctions are not circumvented through companies they own or control in third countries. This means the companies' subsidiaries, so-called daughter companies. This means usually the relationship between parent and subsidiary company. And furthermore, today the companies must implement adequate due diligence and know your customer processes in their operations. It's mandatory now. In other words, especially those companies which portfolio is included the common high priority items. These items that can be, they are dual use items that can be used also in the military purposes, and they are listed in the special EU listing. Must conduct a risk assessment, and based on this, they must build the company internal sanction compliance program and create an adequate sanction screening mechanism and processes aimed at preventing sanction evasions that are sufficiently effective in relation to the risk identified in the risk assessment. This meaning that these companies dealing with the common high priority items, exporting them, they must complete and exercise that kind of sanction compliance procedure, even there is no breach of actual sanction provisions. They must have this kind of know your customer procedure ready, and if they don't have it, it can be offense of criminal law itself. And in addition to this, there must be effort to ensure that the entities owned or otherwise controlled by EU companies in third countries prohibit the export of certain sanctioned products and technologies, so-called common high priority items, which are separately listed as I already mentioned, to Russia in their own agreements with third country partners. And of course, as a novelty, there is also that kind of obligation to report some cases of violations that come to their attention. This is a model of that non-Russian clause which must be included to the delivery agreements in some cases, as I already mentioned you. This is directly from the guidelines of the EU, so I think that I won't get any deeper of it, but it's published by the EU Commission and it can be found there. This is copy-paste directly from the pages of the EU guidelines, so you can familiarize with it yourself. There is nothing special, and EU also said that this is only a model. There is no no actual need to use it as such. The companies have possibilities, if they want to take possibilities to modify it for their own specific needs. But in principle, those facts that this model includes must be found more or less from the model the company uses in their needs. But as you can see, it is quite detailed and takes under consideration many aspects of this trade. Now I have what is left is the summary of this all. I have summarized some main elements of these presentations, and you must always keep in mind when you work in the company the scope of investigation obligation. It is always related to the operator's resources, and as I already mentioned you, this means that certain proportionality is always taken under consideration. The authorities do not expect from the one-man band, shall we say, the same resources, the same possibilities to complete these sanction compliance procedures in the same way as, for example, the world company operating worldwide and having, for example, the separate legal team at their disposal. But you must, of course, try to use your resources as effectively as possible. You must, as I mentioned, you must work as a decent person in a good possible way, bona fide, as they say legally. And it is essential to consider the sanction compliance process in advance. So you have thought through the process, what must be taken under consideration, what elements it must include, what kind is our business activities, and what they require from us in relations to the sanctions and sanction compliance procedures. And consider the implementation in your own operations, and all this beforehand. And the aim of all this is to identify the sanction-free business situation by correctly identifying the situations, the possible red flags, and eliminating all the risk factors that you have found by having extra information, having further negotiations, and if this is possible, eliminate those risk factors, then you can continue. But if it's not possible, then you must seriously consider the possibility to retreat from the potential transaction. And what is extremely important is that all investigation work should be documented in writing for official inquiries. You do this, of course, for yourself, that you have decent files in your company, but especially they are for officials. When, for example, custom criminal unit wants some further information, it is very convenient for you to have a ready-to-use package for this purpose to give to the authorities, and they can straight away see that you have a decent compliance, know your customer process, you have all the documentations, you have find out all the questions that should be clarified, etc. It is very useful, very important, very crucial thing for you. And also this normal active diligence and effort to find out about those things, issues that prevail in the respective case reduces always the possibility of the criminal liability. And what is very dangerous is passivity, negligence, that you don't mind. You think that this is such a minor transactions that maybe we skip the compliance and we take this minor risk and we continue. This is very extremely different, extremely dangerous, shall we say. We cannot recommend that kind of procedures in any case. That means that international negligence arises and gives basis for the possible criminal liability. For example, EastCham and me provides free advice on, among other things, in sanction matters, of course, matters concerning the international trade, especially to the Central Asia, Caucasus and Ukraine, but quite a lot questions concerning the sanctions and sanction compliance questions. Also, the Ministry of Foreign Affairs, their sanction team provides instructions and interpretation assistance. I suppose that at the moment they want all the contacts to be completed via email. I suppose that they have kind of rush there, so they would like all the contacts by email. This is the information package I would like to share with you, and if you have any further comments on the base of this training material or further questions, I would be happy to try to answer them. And if I cannot straight away give you an answer, you can always send me email, and I'm happy to answer you afterwards. Thank you very much.
Thank you, Petri, very much for your thorough presentation. So now we have time for questions. Please, anybody, you can write in the chat or just open your microphone and ask.
I noticed that it was it on page 10 or something? There was a broken link to Finnish Foreign Ministry page. I noticed, and I will copy the correct link to the chat, so you will find. And it was also in Finnish, so this one is in English.
Okay.
And you will also find some additional information from the bottom of this page, so this might be also useful for everyone, so please check.
Thank you, Mikko.
Great, thank you.
So any questions? I have one. You told that there are differences between, if we are thinking about small businesses, one-man companies, and big companies who have legal departments, how to do the KYC. Can you open it up a little bit more, these differences?
I mean only the common resources what they have. For example, the financial resources. Those big companies usually they have in-house lawyers for the first, which know these compliance questions, and then those bigger companies can use, for example, the international law offices, which can complete that different kind of sanction compliance tasks. But smaller, medium-sized companies, they don't have that kind of possibilities. And then usually when we consider the situation afterwards, the officials consider the situation. Of course, they will take this under consideration, and they understand this, and that is what the proportionality means. It means in this case.
Yes, thank you. And in any case, as you told, that passivity is dangerous. So
it is extremely dangerous. That then we cannot help you. I would say that if it can be obtained, seen that you didn't mind, you take the risk intentionally, and you knew that what you should have been done, but you didn't. You just take the risk, and then the situation is dangerous. In principle, you have then committed a crime. That is the case. Activity is always good and needed.
yes, thank you.
I want to say still that I understand that there's quite a lot, it's a very tight package, a lot of information. I understand that maybe those questions will arise later when people maybe read through once again this material. And I repeat that and emphasize that I'd be glad to answer to the questions later. For example, you can send me email, because it's quite understandable that there's a lot of material, and if you are not familiar, especially if you're not familiar with these items, it is understandable that the questions maybe will arise later.
Thank you. That is very good possibility
Yeah,
for you.
of course.
For you all.
That's my job.
So if there are no other questions, this meeting has been recorded and it will be shared in our webpage in a while, and we will also send you, all the attendees, the material Petri presented after this meeting, so you can
Yes.
have them and check them out later. If nothing else, I would like to thank all for participating, and hope to meet you and see you in the future, and possibly in Baku or in some other events. Thank you all.
Thank you very much. Thank you very much for this possibility, and have a nice day.